Today we have Aaron Terr, who is an attorney and a program officer with our Individual Rights Defense Program. Before he got to fire, Aaron studied at the University of Virginia School of Law. He worked as a clerk and a staff attorney at the Superior Court of Pennsylvania and as a volunteer for the ACLU of Pennsylvania. Aaron, I'm trying to remember, how long is it that you have been with us at this point?
It's been almost exactly 1 year. As of January 13th, I think I started last year. So yeah.
Oh, my goodness, because you've so quickly integrated yourself into the fabric of our defense work that I almost feel like I can hardly remember a time without you here, which I think is a testament to how busy we've kept Aaron and how important it is that we are able to have his talents with us. So Aaron, I'm just going to let you get right into it, and we will make room for question and answers. We'll try to save a good 20-25 minutes at least for that.
Sounds good. Yeah. So like Peter said, my name is Aaron Terr, and I'm a lawyer in FIRE's Individual Rights Defense Program, and so also known as IRDP. And IRDP, just to give a quick summary, we engage in non-litigation advocacy on behalf of students and faculty. So if you submit a complaint to FIRE about a violation of your free speech or due process rights, it's typically an IRDP staff member who will respond to you to discuss your situation, get more information. And if we determine that there's a threat to or violation of your rights, we may offer to write a letter to your institution to persuade them to stop violating your rights and take whatever corrective action is necessary to do so. And sometimes we combine that with a public campaign to put added pressure on the institution to do the right thing by writing about the case on our website, on social media, or coordinating with other media outlets. So that's the basic function of IRDP. And just to give a little bit of overview from 2021, this was our second busiest year ever, second only to 2020. In 2020, FIRE had an avalanche of cases, and that didn't let up much in 2021. So we sent 194 letters to institutions across the country, and about 84 of those were on behalf of faculty whose rights were violated. And in those faculty cases, we were successful in almost half of those cases, and we're barely out of 2021 right now, so that number may yet go up. Another significant development in terms of faculty defense in 2021 was the launch of the Faculty Legal Defense Fund, or FLDF. And I think, Peter, you had a previous webinar where you had our Vice President of FLDF, Ronnie London, on to talk about that program. But for anyone who doesn't know, FLDF is a tool to provide free legal help to faculty at public colleges and universities who face a threat of sanction by their institution or have been punished for their expression. So you can submit a case online or call a 24-hour hotline, and if that case falls within FLDF's mandate, they'll connect you with an experienced lawyer in FLDF's network. And since its launch, FLDF has assisted 20 professors. And then one other significant development this year was the launch of the Scholars Under Fire database, which documents instances of faculty facing calls for sanction for their speech and how institutions have responded. Unfortunately, it shows that attempts to get scholars punished or investigated for their speech have increased substantially during the last 5 or so years, and they're often successful. So what were faculty targeted for? Most often, it was for speech related to race, topics like racial inequality, racial slurs, Black Lives Matter, diversity, equity, and inclusion issues, or otherwise hot-button issues such as partisanship, gender, religion, and institutional policy. Another troubling finding from that report is that there are more threats that are coming from within academia, often from students and other faculty, and about half involve the faculty members teaching or research. And there's a lot of other interesting findings in there, so I encourage everyone to check out the Scholars Under Fire report on our website. And now I want to talk about some trends and notable cases from 2021 involving faculty. So I think, first of all, social media continues to be a huge driver of free speech issues that we see. You know, a student or faculty member tweets something, people get offended, a pile-on ensues, and people tweet at the university to do something about it. So one of the first cases from last year was a St. Joseph's University professor who tweeted from his personal account criticizing the idea of reparations for slavery and other arguments related to racism. That led to calls for the university to investigate him. The university heeded those calls, suspended the professor pending an investigation, and ultimately his contract was non-renewed. He's now suing the university. As that case suggests, and as I've mentioned, speech related to race continues to be a bit of a minefield. We've had many cases involving speech on that issue. One prominent one was a case at Coastal Carolina University where two students of color wrote the names of other non-white students on a whiteboard after class. After one of the students said she felt isolated and wanted to get to know other students of color in the department. Then when the next class walked in, they mistakenly thought the students on the whiteboard were being singled out negatively for their race, and those students protested. And that led the department to send out an apology email. A professor at the university, Stephen Ernest, responded that he didn't think it was a big deal, and that you know, and he expressed his opinion that people get offended too easily about these things. And for that, he was suspended from teaching. That one fortunately had a good ending. Our Faculty Legal Defense Fund provided Ernest with an attorney, and we launched a publicity campaign that ultimately led to the university to back down and reinstate him. But you know, another thing to note in these cases is that it's often not even a faculty member expressing a personal opinion. That's the issue. It may just be things that they're referencing in their teaching or in their research. And I think that a lot of these cases are a product of the idea that this idea that I think has been prominent for a while, that impact trumps intent. So the intent of the speaker and the context of the speech doesn't matter if people were offended. Of course, that's not consistent with the First Amendment, and if it was, we essentially wouldn't have free speech, because our speech would always be subject to approval by the most sensitive members of the audience. But so, you know, one example of this is an ongoing case at the University of Illinois, Chicago, where law professor Jason Kilborn included in an exam a hypothetical fact pattern. This was in a civil procedure class, a hypothetical fact pattern about employment discrimination. And within that fact pattern, there was a redacted reference to a racial slur. So it wasn't spelled out, but some students complained about that, and UIC launched an investigation. Fire wrote to UIC explaining that Kilborn's pedagogically relevant exam hypothetical is protected by academic freedom and the First Amendment, and later provided him with an attorney through FLDF. UIC, you know, what makes this case even more egregious is that UIC initially agreed to allow Kilborn to resume teaching, but then when his name reappeared on the class schedule, students protested again. And after that, UIC decided to renege on its agreement and required Kilborn to undergo more bias and sensitivity training before he could return to the classroom. So Kilborn actually just today filed a lawsuit because it's at this point really the last resort option. So we just posted about that on our website today, and so you can read about that, and we'll see how that case shakes out. Um, so another, this is something that's pretty new in 2021, having to do with, we've seen a wave of state laws seeking to ban race and sex stereotyping in K through 12 education and sometimes in higher education. These are sometimes referred to as divisive concepts laws. So FIRE has no position on the parts of these bills that govern K through 12 schools, but we repeatedly pointed out that to the extent these bills ban the discussion of certain ideas in the college classroom, they are unconstitutional. Now, luckily, the bills that were signed into law in 2021 ultimately did not include outright curricular bans, but we did see a few instances of universities misinterpreting their state's law to reach classroom discussion, including most prominently a college in Oklahoma that canceled a course on race and ethnicity. Fortunately, after FIRE wrote to the college, they restored that class. But legislatures across the country are continuing to propose similar bills. And there are many bills pending now in 2022 that do contain bans on what can be taught in the college classroom. So that's going to continue to be a big issue in 2022, and certainly one of the main focuses of FIRE's legislative team.
Hey, Aaron?
Yeah.
Yeah, I thought I might just hop in on that case you were just discussing with the mandatory trainings. I thought maybe we could just parse that a little bit more to talk about why these statutes were being interpreted the way they were. If I'm remembering correctly, it's because they interpreted the word trainings to mean anything that might be mandatory for any student or faculty member. And so some of these institutions were taking a very broad view of what the word trainings meant under the law in ways we didn't think were warranted or necessary. Am I getting that mostly correct?
That is correct. Yeah, I think in all three cases, I think it was three different schools. So there was the case at Oklahoma, where the course was canceled, and that's exactly right. They basically overinterpreted the bill to cover classroom discussion when it only made a reference to trainings. And so when we wrote a letter to the school, we explained that they were misinterpreting the plain text of the law. And we further argued that, even if you could interpret trainings to reach classroom discussion, the bill, the law would be unconstitutional for that reason. And there were two other schools I'm not remembering off the top of my head, but they had issued guidance about the law, and there was a similar problem there, I believe, in those cases where it was the same sort of issue where the bills themselves didn't expressly in their text reach classroom discussion, but the terms about trainings were interpreted that way. So there's one other big issue that I wanted to talk about, and it's again, related somewhat to race and other sort of related issues related to identity. And so, it's kind of the other side of a coin of these efforts to restrict conversations about race is you have efforts by colleges to give more attention to issues of race and gender through diversity, equity, and inclusion, or DEI initiatives. And the problem is that many of these efforts go too far by compelling faculty to affirm the institution's views on DEI or otherwise infringe on their academic freedom. And this can happen in a variety of ways. So many schools require faculty to complete diversity trainings, which generally is permissible, except where it requires faculty to express agreement with university-approved viewpoints. And we've seen that happen and have written to schools about that, including most recently Boston University, and I know earlier in the year, the University of Oklahoma. and what we say to them is basically, you can implement these trainings. They're not per se unconstitutional, but they are to the extent that, the problem in these trainings was that it would ask a multiple choice question, but you would have to select one answer, the university's preferred answer, before you could continue the training. So that amounts to compelled speech. Another issue we've seen is schools requiring faculty to put DEI language on their syllabi. And then another trend that seems to be becoming more and more popular, and we hear from faculty about this a lot, and I know Peter can attest to that too, is requiring current faculty or applicants for faculty positions to submit a DEI statement that affirms their commitment to DEI and or describes their contributions to DEI. And the concern here is, again, that these requirements unconstitutionally compel faculty or private institutions that, go against the promises that those institutions make of free speech and academic freedom by compelling faculty to voice agreement with views with which they may disagree. Or they're otherwise used basically as a tool to discriminate against faculty with dissenting views on issues related to DEI. So these policies, they vary in their content, their source, whether the statements are mandatory or optional, whether they specifically ask about viewpoints, how they define key terms. But some of them are just egregious. We recently wrote to University of California, Santa Cruz, haven't heard back yet, but they require a DEI statement for many different faculty positions in the humanities and the sciences. And the rubric used to evaluate these statements expressly discriminates based on viewpoint. So for instance, you would get a low score for saying, it's better not to have outreach or affinity groups aimed at underrepresented individuals because it keeps them separate from everyone else, or it will make them feel less valued. And that's verbatim from the rubric. So, if you express that viewpoint, then you're put at a disadvantage. To make matters worse, for some positions, applicants are initially screened based on their DEI statement alone. So there's no consideration of their other teaching, research, or service qualifications. We're just going to look at, do you agree with us about DEI? So these types of requirements, while they aren't always as expressly discriminatory as that one, they're increasingly common, and they're going to be a big issue for us in 2022.
Great.
And then one. Yeah, go ahead, Peter.
Nope. Sorry. Although I will use the occasion of my interrupting Aaron to note that we've had a number of questions coming in, and we've had some good questions. I look forward to trying to get to those. But just to tell the rest of the audience that yes, feel free to add your questions. We will do our best to answer as many of them as we can in the time we have. We're not going to go too much past 5. We're going to try to keep this close to an hour, even though I got us started a little bit late. So we'll end a few minutes past 5. If we don't get anything, if there are questions we aren't able to get to, you can email either Aaron or myself. Yeah, that was what I was going to say there. So Aaron, if you had more, please continue.
Sure. Yeah. So the last trend I was going to identify, that I think this is an old one. I think it'll never go away. But just in universities that stifle faculty speech when it's critical of institutional policy or leaders. And I think one of the most prominent examples of that from last year was at Collin College in Texas, where 3 professors were fired in part because of their criticism of the college's handling of the COVID pandemic. FI represented one of those professors, Laura Burnett, in a lawsuit against the college, which fired her not only for criticizing the college's policies, but also for a tweet insulting Mike Pence. And just this week, Burnett prevailed in that lawsuit, accepting an offer of judgment from the college. And then I think one of the most interesting cases in this category is a university that actually FOIA'd its own professor this was at Indiana University. A law professor, Steve Sanders, wrote on his personal blog criticizing the school's secretive presidential search. And the university responded by hiring a law firm to make a public records request for Sanders' emails relating to the search. We were able to uncover through our own public records request that it was the university that was behind this public records request for the professor's emails. They were essentially bypassing their own policy that restricted them from, snooping through faculty emails without cause. They also charged Sanders with violating university policies. So that was a pretty egregious case. I think that was, there's plenty of other cases I can talk about if they're relevant to any our discussion. But those were some of the major trends I wanted to touch on. I'm happy also to talk about how faculty can be prepared to defend their rights. But I don't know if Peter, you want to stop here and take some questions, or how you want to proceed?
We can start taking questions, definitely. And if we have the occasion to for you to give some of your most frequently dispensed advice in terms of just basic due process, in terms of faculty better protecting themselves in the case of a potential investigation, if they're at the center of a controversy, I think it would be great for us to give a little bit out in that regard. We've got a number of questions. I'm going to go through them quickly. Aaron, I wonder if while I'm going through the questions and queuing them up, if you might talk a little bit also about the public records aspect of your work, because I keep forgetting that you're a public records officer with the organization as well. This is something in recent years that we have employed a lot more than we had in the past. It's become much more of an institutional part of how IRDP does its work, and I'm curious to hear from you sort of more how it factors in the daily work over there.
Yeah, sure. So a big part of my duties in IRDP is to engage in public records requests, and we most often use those to assist in our investigation of cases. One way in which that's often useful is that, a lot of times the university itself is maybe not going to give the most forthcoming explanation of its actions or the reasons that it took particular actions that may have violated a student or faculty member's rights. So public records requests, if it's a public institution, of course, can be a great tool to obtain records, obtain, say, communications between administrators, reports, or what have you, and basically get evidence, obtain some evidence about what's really going on, what really motivated the university's decision, and that enables us to potentially rebut a pretext that the university comes up with for a decision that it takes to violate a faculty members or students' speech rights. It can be a very useful tool. I'm just trying to think of I did just mention the example of the university that FOIA'd its own professor, and how we were able to use FOIA ourselves to find out that the university was behind this FOIA request that was actually submitted by a law firm. We're also still investigating this recent case at Dartmouth College. This isn't a faculty case, but just as an example of using public records. Many of you may have seen that a student group there had invited Andy No, the activist and journalist, to speak at the college, and there was a lot of opposition from the left and from Antifa organizations, and there were some threats of violence on Twitter, and the university or the college ended up canceling the event right at the last minute, even though there had been lots of precautions taken to provide security from local police departments and the college claimed that there were security concerns, in part based on, what they had learned from the local police that forced them to shut down the event at the last minute. So what you can do in that situation is you submit a public records request to the local police departments and find out, were there threats? What were their communications with Dartmouth? And find out, did they really have a legitimate justification for shutting down this event at the last minute? Or was that all just a pretext because, the amount of just opposition there was to this unpopular speaker? So public records requests are, I would say, an incredibly useful tool for IRDP. And it can just be a fun part of the work that we do.
Thank you. Along the lines of our FOIA discussion, I had a question. It's a really good one, and you might have a quick answer. This might actually, in fact, be something that we already do in certain contexts. But would FIRE be willing or able to make a tutorial project of how faculty or students could file a FOIA request with their institutions? I'm sure that is something that we are more than happy to do. And like I said, probably something that we have done in certain contexts, because I know that we do a lot of work with student journalists. And I think one thing that you teach a student journalist, that you teach any journalist getting their feet wet in the business, is how to make proper use of FOIA and how to submit a good public records request. Aaron, I might be forgetting some of the resources that we have in that area. Can you comment more on that?
I think that Adam Steinbaugh, our director of IRDP, has at least written an article on our website about how people can submit their own public records requests. So yeah, that may be something that if we can somehow get that to whichever faculty member or members are interested in that. I think that could be, I think we do have some useful resources already, but I would definitely be interested in exploring the idea of maybe, making something, putting something on FIRE's website that's maybe a little more informative or comprehensive in that respect. So that's I think that's a good idea, and that's definitely something I can take back and discuss with.
I can even see
Adam
us. I can even see us doing one of these types of webinars around the topic with faculty who've been successful in employing FOIA in this area. So definitely stay tuned. I think
absolutely.
I think it's a great idea for a resource. I think it's a great idea for a future discussion. Definitely it's something that we get questions about. So stay tuned. I think there's definitely room for us to do more for faculty there, and we'll get to that.
Absolutely.
Okay, and I did in a moment. I did find one of those how-to articles that Adam Steinbaugh wrote, so I will send it out to the chat. Another question, Aaron, this is something you and I have discussed. I think we've actually discussed it fairly recently. Question that we have before, and again, we're talking about DEI related issues and statements and all that. Before asking FIRE to intervene, what else might we recommend for faculty to do on their own? I think you and I've said, we've taken some time trying to parse out what those options are. So I wonder if you might have a little more comment there.
Yeah, I mean, I think it's always useful for faculty if you can find like-minded faculty on your campus who feel the same way about these initiatives, who feel that they compel speech, they infringe on academic freedom, and sort of band together to put pressure on the institution to respect academic freedom and not get kind of carried away these types of initiatives. It's I mean, that's definitely one thing that I think can be helpful. I would say that we typically get involved at the point that there's really like a concrete plan on the ground. I mean, these things are these types of policies are becoming so common that sometimes we get asked to help with when it's still in like a very incipient planning stage, but there's nothing really in specific in writing yet as a sort of proposed policy. So we can't weigh in on every single one of those. But that's kind of the point where we can get involved is when there's a specific policy that it looks like it compels speech or otherwise infringes on academic freedom. But I don't know if Peter, if you have other thoughts just about in terms of what else faculty can do themselves.
Not too many on top of what you've given. I think that's pretty good. Although that is something I am happy to follow up with you privately on, because it is something we do get questions about. I'll say one other thing is I've heard these general questions and concerns from enough faculty that one thing I want to make our network better at doing is connecting those faculty with each other without them having to come through us. That's sort of a moonshot project given the size of the department, given the number of hours in the day, but it is something that I do want to do. There are any number of professors who have thought long and hard on this, and I'm sure would be happy to take a minute out of their day to try and answer the questions of faculty at other institutions who might be wondering these things. So that's another long-term goal of mine, and I think if we can get the faculty network steered in that direction, I think it could really do a service. So stay tuned for that. But that's another of my long-term goals for the program. Okay. Let's see. Gonna try to clean up. Okay. Another one more DEI question. It's a simpler one, which is what limits, if any, apply to mandatory DEI trainings at private institutions, which is a good and sensible question, because a lot of what we talk about this is about a lot of the discussion revolves around sort of where it falls in the realm of First Amendment law, which obviously doesn't apply at a private institution. So what might you say there, Aaron?
Yeah, so I mentioned earlier, we wrote to Boston University recently about one of their mandatory trainings. I think it was on harassment and discrimination that essentially required faculty to agree with universities' viewpoints on certain contested issues of social and political concern. So like Peter said, the First Amendment doesn't apply at private universities, but many institutions like Boston University make very robust promises of freedom of speech, of academic freedom to their faculty. And that's for good reason, because they recognize that that's sort of the linchpin of academia and higher education. So the argument we make in those cases is that while you're not bound by the First Amendment, you make these promises to your students and faculty, and they have an expectation of enjoying freedom of speech and academic freedom. That's essentially going to be consistent with our understanding of those values as informed by the First Amendment. And so we'll appeal to the Supreme Court's interpretations of the First Amendment as sort of this reflects as a society, our common understanding of free speech. And so, we tell the university, you're bound by these commitments and you should uphold them. And in the case of a mandatory training, just like under the First Amendment, there's a right against compelled speech, because any sensible notion of freedom of speech is going to include both the right to speak and the right not to speak, not to endorse views that you disagree with. So we'll just as readily advocate on behalf of a faculty member at a private university if there's a mandatory training that involves compelled speech, as long as that university makes promises of free speech or academic freedom, and often they do.
John Wilson has a good question. I'm gonna read it out here. Suppose someone thinks scholarly merit or professionalism are code words for conservative racist standards and opposes them. A university can require applicants to describe their commitment to scholarly merit and professionalism. Isn't that viewpoint discrimination in the same way that DEI statements are? And, it's a fair question, and it's a good one. In the sense that a fair bit of viewpoint discrimination probably, like, to use the term very broadly, goes into the overall hiring process in terms of hiring someone based on the body of their scholarly work, the approach, the approach they're taking on a certain subject, how well it jibes with the academic mission of a department or program they might be applying to. It's a really good question. It's one that we've been thinking about at FIRE for a long time. It's one also, I think, at our most recent conference, and I see, and some of the people on this call I met at our conference in Chicago last year. We had Brian Suchek, a law professor at UC Davis, giving a presentation on the controversy around diversity statements, where it falls legally, and it puts sort of that same question, and it's a really good one, and it's one that I think, Aaron, part of what the challenge is that there's so little body of law on this compared to so much of the other First Amendment work that we've done.
Yes, absolutely. I mean, it's definitely not there hasn't been a case, to my knowledge, in any court that's actually challenged one of these statements yet. But I think, I take the point that, perhaps, there is some necessary viewpoint discrimination going on within academia. Although, I would say it's not actually clear to me that, at least it's not clear to me that there has to be viewpoint discrimination when you're evaluating, a faculty candidate. It's like, so for instance, a faculty candidate might have some absurd view, within his discipline. But, maybe this is splitting hairs, but I think you can say that if the rejection of that applicant is really based, I mean, there's a consideration of viewpoint involved perhaps, but it's really based on his disciplinary peer's judgment that he fails to reach scientific conclusions based on sound methodology and reliable evidence. So I think, there's ways, I think you can evaluate a candidate, using, there's certainly going to be content discrimination, right? That's acceptable. So if you're a biology professor, but you're, all you're talking about is like your history credentials, then that's going to count against you. But when it comes to viewpoint discrimination, and I think, on top of what I already said, I think there also is, I think that you can draw a distinction perhaps between just, are you in favor of scholarly merit as just a general principle, versus with some of these DEI statements, the very kind of specific probing into like rather specific views about diversity, equity, and inclusion, like the one that I mentioned earlier at UC Santa Cruz, about whether you think affinity groups are a wise or a counterproductive idea. It just starts to get into very kind of specific, sometimes specific political or ideological ideas that I think that's distinguishable from something like just, are you enthusiastic about teaching in general? but I agree with you that it's an unsettled area, and it's one that internally we're still giving a lot of thought to, and it's I think it's going to be interesting in the next year to see how these issues shake out.
Definitely. A question. Oh, hang on. I've lost my place in the. Okay, here we go. A question we had come in around the midpoint of the discussion, Aaron. It asks about just some of the potential factors in why our caseload has reached the level it has in recent years, the extent to which polarization, the extent to which corrupting influences of things like social media on the discourse, the ease of things going instantly viral. I'm curious, you haven't been here particularly long. I worked in IRDP for a long time, but I feel like the things that factor into our cases have changed a lot in a handful of years since I left it. Do you have any particular thoughts on that, on what you think might be motivating the increase in the caseload, and where that might go?
Yeah, I mean, my sense of it is that it's a few different factors. I do think social media is part of it. I think with social media, people have an opportunity to express their opinions to a very large audience in a way that wouldn't have been as possible or easy back in the day. And we've seen how with the way that people can like tweets and retweet, and I think all of that facilitates the ability of people to target a tweet that they don't like and blow it up and grab the attention of universities. Often you'll see it in these cases involving social media that people will the university has its own account, and people, one person after another is tweeting or sharing this thing that professor or student said with the university, and they, I think, feel pressured to say that they're going to do something about it. So I think that's a big part of it. I would agree that increasing polarization in this country is certainly playing a factor. And I think more specific developments like with all the increase in DEI initiatives and issues, I think a lot of that goes back to 2020, mid 2020, before I started at FIRE. But when you had the killing of George Floyd and the racial justice protests that erupted after that, I think that really brought issues of race front and center. And it's just one of the most divisive issues in this country. And it also put a lot of pressure on universities to respond to demands to do something about their perceived lack of diversity, equity, inclusion on campuses. Yeah, I think those are two big ones. Peter, what would you add to that?
I think you've said it pretty well. I think part of what always factors in is that as the years go by, I think our profile goes up a little bit more, and a few more people are aware of FIRE as a potential resource. So I think I think there's the added visibility factor, but there's also, I think, I've watched the IRDP program grow in terms of the number of staff, and that doesn't seem to have done very much to decrease the average amount of work going around the department. I almost feel like the more you hire, the more you can take on, and therefore the more that is guaranteed to come in. It just seems to be a foolproof logic. I don't know how you all get a good night of sleep over there.
Yeah, we're busy.
We've still got a few minutes and a few more questions. We've had a question. One of the biggest things going on one of the biggest higher education controversies going on right now is the one over Professor Amy Wax at Penn, and it's something that we have that we've written on fairly recently. I'll pull it and I'll send it around. But Aaron, I wonder if you might be able to kind of talk about where where Fire's thinking is on that. What our lines are, and it's just sort of like how like our take on this this explosive controversy, which is manifested in ways I'm not sure how many times I've seen, in terms of a whole city government and a lot of the state government pressuring the institution to fire her. Granted, this is something we've seen a lot in more red state governments, in terms of calling for the firing of a professor, very frequently on the basis of something posted to their Facebook or their Twitter account, or something they're alleged to have said in class. It's a big controversy. It's an ongoing one. Aaron, I wonder if you might just be able to sort of elucidate us on that.
Yeah, so Amy Wax at Penn, she a law professor, and it's part of the issue here is that it's not her first controversy involving comments related to race, but her most recent comments were on the Glenn Lowry show. So this was speech that was totally outside the context of the school. Extramural expression, and she made comments about Asian immigration that offended a lot of people, and like you said, led to action by local city government officials to put pressure on Penn to do something about this. And sure enough, they have now the dean there, after initially offering somewhat of a defense of her academic freedom, has now launched an investigation into Amy Wax. So it's it's just a very fundamental principle, again, that when you're in Penn is a private institution, but again, they make robust promises of free speech and academic freedom, and when you do that, it's a cardinal principle of free speech that speech that is offensive is not punishable for that reason alone. On top of that, when it comes to free speech and academic freedom, when a professor speaks, not in the classroom, but outside the classroom, outside the school on their own time, that's when their speech rights are at their height. That's when the university has the least justification for imposing punishment on them for something that they said. And that's the case here. I think one of the additional wrinkles in this case is that there are a lot of people who are claiming that Amy Wax as a teacher can't be trusted not to discriminate against her students based on the views that she's expressed about Black students, about Asian people. But our response to that is that you can't sanction a professor based on a prediction that they're going to engage in discriminatory conduct based on something they said. And to be clear, she's never said I am going to discriminate against my students, or expressly said anything like that. Professors, of course, can be punished if they actually engage in discriminatory conduct, if they actually treat their students differently on the basis of race. But there is no evidence that Amy Wax has actually been doing anything like that. Until there is, our position is she's just being punished for pure speech, and there's no basis for Penn to do that under their own promises of free speech and academic freedom. And there's certainly no basis for local government officials to be, coercing or pressuring Penn as an institution to punish her for her speech, because there you do start to get into a potential First Amendment issue. And that's complicated because government officials, politicians do have their own First Amendment right to express their views on issues, but at some point, if they're essentially coercing or making threats to private institutions to punish someone for their speech, if, for instance, if it was more blatant where they were gonna, if the local city government was going to deep six some deal, business transaction or deal contract it had with Penn, or otherwise, threaten them with some kind of sanction for not doing what it wanted to do here and punish Amy Wax, then that would be a violation of the First Amendment by the city government as a government entity.
Thanks, Aaron. It's a few minutes after 5. I think I'm gonna do one, maybe two more, and I'm sorry that we're not going to have time to get to every question. I thank you also for giving us such excellent questions on this discussion. One question, I'm going to find it. In terms of our caseload, Aaron, you might know this better than I would, but question, do they only arise in schools which score badly in our rankings of campus free speech? And I would say, the short answer to that would be no, they can happen. They can happen anywhere, and they do happen anywhere. But I wonder if you might have a more nuanced look at that, because I know some of the major free speech controversies that we've seen at campuses, some of the most prominent ones from last year, the University of Florida with its blocking the professor's testimony against the state, the University of North Carolina, Chapel Hill with its botched hiring of Nicole Hannah-Jones and that whole controversy with the Board of Trustees. These are major national headline grabbing controversies that happened at institutions that get our highest free speech rating in terms of getting our green light rating. And I don't know exactly where they fall in our campus rankings. There were 159 schools, I think, in our latest one, and I don't remember all those. But the short answer is no. It really can happen anywhere. Aaron, I wonder if you might have a more nuanced look at that.
Yeah, well, you're right. It can happen anywhere. And one thing to note about the free speech rankings is they're only taking into consideration policies regarding student expression, right? So, you could still have theoretically have policies affecting faculty expression that aren't so great. But generally, I think that the schools with better rankings, with green light ratings, schools that have adopted the Chicago Statement, which is our gold standard for free speech policies, those schools, and our statistics bear this out, they tend to be more likely to stick to their free speech promises than schools with lower rankings. So they tend to be more speech protective for both students and faculty, because I think if you're a green light school, then there's protection, or tends to be you have good policies protecting students, and faculty are protected too, at least on the books. So you're less likely, or you're more protected at those schools. But like Peter said, it's not. They are just, at the end of the day, written, words on paper, and the school has to actually commit to them in practice. And we have seen, there are, of course, instances where they fail to do that. And so, but I think, it's always better if a school does something like adopt the Chicago Statement. I think it does go a long way toward creating a culture of free expression on campus, in which students and faculty can feel more free to speak their minds without fearing institutional sanction.
Thanks, Aaron. We're about at time, but I wonder if quickly, since it isn't something that we found much time for, and I apologize for that. If there is one quick tip you might give in terms of what's among the most important things that faculty can do to protect themselves if they find themselves under some investigation or at the center of some controversy, is there a good piece of advice you dole out with particular regularity?
I think one is to make sure you know your rights and your obligations. So if you're being investigated, know what type of due process protections you're entitled to. And if you're at a public institution, you're entitled to certain due process protections under the United States Constitution. And if you're at a private institution, often you'll be entitled to some due process that's laid out in the faculty handbook. So, for instance, you want to know whether you're allowed to have an advisor or a lawyer present at a meeting or a hearing that you're required to attend. No deadlines. So, know the deadline to respond to charges if they're filed against you, the deadline to appeal an adverse finding, and be wary about waiving your rights by not responding to charges, by blowing off a meeting, by failing to timely appeal. The university can turn around and say, well, now you've waived your right to challenge this. And then another quick thing I would say is contact fire as soon as you think that there might be some sort of threat or violation of your rights, because it's always better for us to intervene at the outset of an investigation or at the outset of a potential issue than after you've already been found responsible for misconduct. So the sooner we can get involved, the better. And if it's too soon, we'll tell you that, no harm done, and we'll probably just ask you to keep in touch if anything more comes of it.
Great. Well, Aaron, thank you. And thank you everyone for joining. And again, I apologize for the technical difficulties that got in the way of us getting started on time. I really thank Aaron for putting up with that. And I worry the problem was on my end. I'm going to get to sorting that out and seeing what the devil happened so that it doesn't happen again. But thank you everyone for joining. I'm really pleased that we had the turnout we did, and that people didn't peel off when we were having those difficulties at the top of the hour. Stay tuned for our faculty network announcements. We'll be having more of these in the course of the spring, including I hope a good one where we can talk about the public records and FOIA aspect. I think that's a fantastic idea for one of these discussions. So stay tuned, and thanks again, and hope that you all had a good holiday season and New Year, and that you've stayed safe and healthy in this time. So thanks again, and again, feel free to email either of us, peter@thefire.org, aaron.terr, Terr. Give it there's. So everyone, thanks very much. Have a great day, and thanks again for bearing with us. I'll try to do better on that next time.
Thanks, Peter.
Thank you, Aaron.